right to remain silent. Anything you say will be broadcast on the air. John Fuller is in the studio. He's an attorney with the law firm of Fuller and Fuller. The other Fuller is his wife, Janet. She's not only an attorney, but she's a registered nurse. The show is called Legally Yours, and John does this show so that he can help us better understand our own personal circumstances. It's not a show to discuss the presidential campaign, unless, of course, John brings it up himself. He's mostly asking for your questions about your situation or maybe somebody you know, and that's why the phone number is important. It is the WOCA Climate Control Source Hotline, 622 WOCA. If you're out of the area, maybe you're watching online, and I see some of you are, then the area code is 352-622-9622, and I'll also set this up so I can see if you're texting us. So if you have a question and you'd rather text it, I will read it to John. John Fuller. Good morning, John.
Good morning, Larry, and good morning to our friends who are listening in on the radio. And it's nice to be here.
You got some watching too. It looks like.
Well, that's good. I make sure I'm presentable.
Make sure your tie is going up, yeah.
It's nice to be here. I was tied up with some hearings last week and had to have a rerun, and I always miss getting a chance to visit with you about legal issues. As you said in the lead-in, I practice law with my wife, Janet, at Fuller & Fuller Law Firm. Janet specializes in Social Security disability claims. If people have a question about are they eligible to receive Social Security disability because they are unable to work, call our office. Janet would be happy to schedule them an appointment. That's her area of specialty. I do civil trial work primarily in personal injury, wrongful death, business and commercial litigation, and a select number of complex involved family law cases that usually have some type of a business commercial overlay, such as the ownership of a business, a corporation, a professional association, where there are issues that are similar to the litigation that I do in business and commercial litigation.
Okay.
So if you have a question, so many things in the law are so fact dependent. I enjoy, and I hope our listeners enjoy and get some benefit in talking in general terms about issues. But if you have one, call us and we'll be glad to try to help you.
All right, excellent. And it looks like you have one. Good morning. You're on the air with John Fuller.
Good morning, John.
Good morning. So how are you?
My car telephone blocks out things, so I didn't hear your lead up. Two quick questions. One is for me, one is from Larry. What is a holographic will? Is it legal in Florida? I know this is not your specialty, but in an earlier show we were talking about a guardian ad litem. Any idea what ad litem means?
Yeah.
I'm going to hang up.
I was asking that. Yes, thank you.
Okay, let me back up to question number 2 first.
Okay.
In Florida law, they are sometimes people who are involved in some type of a controversy that leads to a lawsuit, and for one reason or another, there is reason to believe that they are not able to protect their own interests. You see this very frequently in family law matters where the mother and the father are at odds over parenting issues. And the court will, upon the motion of either party or sometimes upon the judge's own motion, appoint what is known as a guardian ad litem. And I want to make the distinction because it's confusing, and even lawyers will oftentimes interchange the terms. But there is a distinction. A guardian ad litem is someone who is to look after and to see that the best interest of the ward, the person to whom he or she has been appointed as the guardian ad litem, that their best interests are served. That could entail seeing that their finances were protected, seeing that they got the health care they needed or that they got to appropriate counseling, and making a recommendation. This would ultimately all come from an order from the court, but the guardian is not on the side of either litigant. He or she is there to look after the well-being and the best interest of the person that they have been appointed for.
Okay.
The guardian ad litem usually, but not necessarily exclusively, is a lawyer. Now, the lawyer as a guardian ad litem is not serving as the attorney to argue a legal position for the person that he or she's been appointed to protect.
I got you.
There is another position that is known as an attorney ad litem, and that is when there is an individual, usually a minor, but it could be someone who has some degree of impairment, either incompetency or inability to manage their own affairs because of some mental or cognitive disability. And they are involved in a lawsuit that involves them, and other people are prosecuting or defending the lawsuit, but the individual, say in this case a minor, has an attorney ad litem appointed to represent them. And in that case, the attorney is arguing the legal position that is in his client's best interest. Okay? So there's a distinction between an attorney ad litem, a guardian ad litem. Let's say in a divorce case, a guardian ad litem is appointed, and that guardian ad litem makes a recommendation to the court as to what is the best parenting plan for that child or children to have time sharing, and which parent should make which ultimate decisions, or should they share all parenting decisions equally. The guardian ad litem will make that report. Now, let's take it with the same scenario where you have a minor child and there's a family business, and the parents at some point in time, for one reason or another, has placed stock in the name of this minor child, and now the parents are getting divorced, and there is a big dispute on how the family business is to be disposed of, and there's a lawsuit to dissolve the family corporation filed by one of the other parents. The child, as a shareholder, is a necessary party to that lawsuit.
Oh, really?
You would not have a guardian ad litem. You may have a guardian ad litem to recommend things like parenting, but to come in and represent that child's interests in the dissolution of the corporation, in the business litigation, if you will, you would have an attorney ad litem who would come in and argue that.
Oh, I hadn't even heard the phrase.
Yes, holographic wills, and I hesitate to get into this very much because I have said repeatedly I do not do wills, I do not do estate work. That is not an area of my specialization. Holographic wills are self-written wills, as I recall, and for anyone who has questions about their estate, or anything to do with the trust, or anything to do with the probating of a will, or the probating of an estate in connection with a relative or with themselves, I encourage them to call a lawyer who specializes in that and have a consultation with them.
The phrase ad litem, that sounds Latin. Is it, and what does it mean?
Yes. Well, I believe I know what it means, and I may be mistaken. But it's like we talk so many times. A lot of these archaic terms are vestigial holdovers from old tradition that was handed down from the English common law that we have. Ad litem means as to this litigation, I believe. So if it is a guardian ad litem, it is a guardian for the person for the issues that are at issue or at litigation, or an attorney ad litem for this particular lawsuit. I think that's what it means, but it's one of those things that you use every day. You know what it is, you know how it works, you know how how it applies, but other than having a vestigial carryover, we have so many of those things in the law. We have a theory. If you're hurt in an accident, there is a theory that's called res ipsa loquitur.
Oh, wow.
And it's 3 words, and it's unique, and it's somewhat humorous that we have that, but it becomes tradition, and it becomes ingrained. And what it means is the thing speaks for itself. If something happens that is so obviously inappropriate to have happened, if there had not been negligence or something like that, there's a theory you can sue on that says the thing speaks for itself. If you walk into a store and spontaneously the light that is hanging from the roof breaks and falls and hits you, you may have a theory of res ipsa loquitur, that the thing speaks for itself, there had to be some negligence, because those things just don't happen.
No, well, yeah, you would hope not, right?
Yeah, if something is done properly and with due care and was not negligent.
When you have a client who has come to you for help, and you see a few things that need to be done, and they are reluctant, or they're kind of questioning your ideas on what they need to do to protect themselves, is that it? I mean, do you throw your hands up and say?
That's a very good question, and it comes up from time to time. And I tell folks, look, picking a lawyer and having a successful lawyer-client relationship is very important. It's very much like picking a doctor. There are many, many fine doctors and many fine lawyers, but they may not be the right doctor or the right lawyer for that individual in that particular case. The lawyer is there to advise. He's there to give his opinion. He is there to point out the pros and cons of various courses of action. He is there to make recommendations. The client is the person who ultimately makes decisions, and as long as the decision of the client is not illegal or asks the lawyer to take a position that would be contrary to the Code of Professional Ethics, then the lawyer is free to pursue a course that the client may want to pursue, even if the lawyer thinks it may be improvident. That's usually a very difficult relationship to try to sustain, and I encourage people, if I make a recommendation and they do not feel that they are comfortable with that, I have always been one to suggest that they get a second opinion with another lawyer. From time to time, it is rare, but from time to time, you will get into a situation where irreconcilable differences arise between the lawyer and his client, because the client simply will not cooperate with the lawyer, will not follow the lawyer's advice, and the lawyer can no longer be responsible for having any chance of success in the outcome of the case, because the client, for instance, if every time you go to the courtroom before the judge with your client insists on standing up and telling the judge that he thinks the judge is an idiot, well, that's totally inappropriate. And he may find himself in contempt of court and in jail. But if you tell him, that is not appropriate, you cannot behave that way, that is improper conduct, it not only can end up with you being held in contempt of court, it is certainly damaging to your case and very detrimental to my ability to help you. And if the person just rejects the lawyer's things, and that's obviously an extreme example, but they continue to do some self-destructive thing that is going to ultimately have a high likelihood of destroying any chance the lawyer has of winning the case, then the lawyer-client relationship at that point may have eroded to the point that it simply can't function, and at that point the lawyer and the client should part company. Ideally, they would do it cordially. The client would go find a new lawyer. There would be a substitution of lawyers, etc. One of the problems is that the closer you get to trial, the harder it is to change lawyers, because judges are reluctant to delay trials for last-minute changes of lawyers. So you can't always count on that. And if you are in a case representing a person, you can't withdraw or quit without getting the permission of the judge. It's not like a contractor who's building your house, and if you don't have a good relationship with the owner, you can just say, okay, I quit. You have to get court approval, because you're not only representing the litigant, you're also an officer of the court.
The phone number right now, if you'd like to speak to John, is 622-WOCA. That's 352-622-9622. And that is the Climate Control Source Hotline. You can also ask questions online. If you're looking at the streaming video, click on the lower right-hand corner if you're on the WOCA page, and it'll take you to the host of the video, which is called Ustream. It's a website. And then there you'll have on the right-hand side an area where you can send questions, and I will read them to John if you do that. Good morning. You're on the air with John Fuller.
Yes, good morning, John.
Good morning, sir. How are you today?
Fine, thank you. How are people selected for jury duty, and how often do you have to serve in a year's time?
My recollection is that if you have served on a jury, you do not have to serve again for at least 1 year. There's a statute that specifically provides it, and I believe that is the time frame, although I confess I have not looked at that statute recently, but I believe that is the case. The way you are selected on a jury is that if you have a Florida driver's license, you have a likelihood or a possibility of being chosen, because prospective jurors are chosen from all of the licensed drivers in the state of Florida. And if you live in the 5th Judicial Circuit or in Marion County, you have a chance of being called for jury duty. You would get a summons. The statute provides that there are certain automatic disqualifying features, such as if you are a parent, that there's the primary caregiver to a small or infant child, you can check that and have an automatic deferral. If you have any physical disabilities, such as hearing impairment, sight impairment, or other physical or mental limitations that would prevent you from being physically or mentally able to serve on a jury, that is it. Those are kind of the standard things. If you're over a certain age, I believe there is also an exclusion. Now, just because you might have one of the statutory automatic exclusions doesn't mean that if you want to volunteer to be a potential juror that you are prohibited. You can go down there. You don't have to assert those statutory rights. And then the people who assemble each Monday in the jury assembly room at the Marion County Judicial Center, and they usually call in several hundred for all the jury trials that are going to be done by all the judges that trial week. You are pre-qualified, and that the clerk comes in and makes sure that you're a lawful age, that you're an adult. That makes sure that you are not a convicted felon, and you are then pre-qualified that you do in fact live in Florida and are a Florida resident, and so forth and so on.
Right.
And then your name goes into literally a box or a hat or a container or whatever. And you're assigned to a courtroom, and the court clerk for that trial picks a number. You're assigned a jury number. They pick the number out, and your number's called. You go into the jury box, and then the process of selecting a jury begins, where the judge will ask you certain preliminary questions that are geared to find out whether or not you are a suitable person for that case. Doesn't mean you're a good person or a bad person or a good juror or a bad juror.
Yeah.
If it happens that you just happen to get called and you're sitting there and the person who is on trial is your brother-in-law, you're probably not going to be the right person to sit on that case.
Right.
If it is a case in which someone is suing a local business, and you happen to also do business or have a business relationship with that business, it might not be the right thing. So a lot of questions are asked. They're not designed to pry into your privacy.
Yeah.
No one wants to embarrass anybody in the process, but only fair jurors and fair juries can dispense justice in our system.
Yeah.
And that's what we're all out, so that everybody, when the trial starts, both sides of the case start out with a level playing field.
Yeah.
So the process, which is known as voir dire, which is, I think, comes actually from the old French, not Latin, which means to speak the truth.
Yeah.
The lawyers get to have a dialogue with you and to find out a little bit about your background and if you have any preconceived strong feelings that would make it hard for you to be totally neutral and unbiased.
Okay.
I'll give you one quick example. Many years ago, I was defending a young man who had been charged with a drug offense. He had been arrested in a reverse sting where law enforcement had gotten a very attractive young girl to approach him and to speak with him about trying to obtain a controlled substance for her. And our defense to that case was entrapment, and that was the theory of our case. And after doing a fairly long and detailed voir dire, I asked one of the prospective jurors, actually I asked all of them, how many of you have bumper stickers that you have on the back of your car?
Yeah.
And one individual raised their hand, and I said, do you mind telling me what your bumper sticker says? And the individual, I can't remember whether it was a man or a woman, and he or she said, yeah, my bumper sticker says, turn in a pusher. And so that is what you call a clue that they may have strong feelings and not be able to view a case completely open-minded with no presumption either for or against either side if they have such strong feelings.
Is it possible for the two people of the same family to be on the same jury?
That's a good question, and I don't know of anything that would necessarily prohibit it, but one of the questions that I ask every prospective juror is, do you know anyone else that is in the jury box with you who might be serving on the jury with you?
Okay.
And that's a very important question, and ironically it's a question that I have seen in watching trials a lot of lawyers fail to ask, and I think it's an important question because if you have two people who know each other and have a relationship, there is very likely one person in that relationship who is more dominant than the other person.
Right.
So are you really going to be able to have the individual thought and consideration of each juror, or are you going to have one juror who's just going to be someone who will be in the Me Too category with his or her friend who might be on the jury?
Wow.
So anyway, those are all little tricks of the trade of picking a jury, and it's certainly more art than science. There are psychologists now who specialize. Dr. Phil got his start this way by being the jury picker, the juror selector expert for Oprah Winfrey when she was on trial, and she was impressed with him. He was a psychologist, and they're supposed to help you design questions that that will elicit the true motive of the individual.
Yeah.
You really don't get to pick a jury. You have a number of challenges. Some of them are challenges for cause. If, for instance, the juror says, yeah, the defendant's my brother, that's a challenge for cause, because obviously there would be a bias. A peremptory challenge is when there is no particular discernible reason that you have to articulate, but you have concluded from the way they answered the question or any other number of intangibles that that person may not be the person who would be the most fair-minded individual for that particular case.
Right. Okay, very interesting. Thank you very much.
My pleasure. Thank you for calling.
And that sounds like it illustrates why one would be wise to not decide to represent themselves. I mean, you hear about these cases all the time where somebody, like the guy with the donkey, he said, "Oh, I'm going to be my own attorney," and
well, obviously, trial work is very complex.
Yeah.
We have a large body of law that encompasses the rules of evidence and rules of procedure, and then we have the substantive law of which the case grows out of. And preparing for and trying cases is very hard work. It's very time-consuming. It's very expensive, and it is not something that I believe any layperson would be well served to do. And I don't even think lawyers ought to represent themselves. You know, the old cliche that the lawyer that represents himself has a fool for a client. It's very true, because you lose objectivity, you become angry, you are unable to focus properly and be objective. That's the same reason doctors normally don't treat their families, because you're not able to step back and exercise that independent, dispassionate judgment that you need to do to be able to do the best job you can for your client.
Does the judge sometimes step in, not as an attorney per se, but let's say somebody represents themselves and the judge says, "Let me just help this guy along a little bit"?
It is a very difficult position for judges, and I empathize with them when they are in that. The judge wants to see that justice is done, but the rules say that the judge should not give a litigant who chooses not to hire a lawyer an unfair advantage by bending the rules in favor of the person who doesn't have a lawyer.
Right.
That would be reverse prejudice to the person who did hire a lawyer. So the judge is required to enforce the rules equally against both parties, whether they're represented or not. The judge is interested in trying to avoid an overt violation that might create a mistrial, and it puts the judges in a real dilemma a lot of times, and I always empathize with them. I know judges much prefer when parties are represented by lawyers. The case goes faster, it goes more smoothly, there's less likelihood that there will be reversible error, that the case would be reversed and have to be retried, and it usually is a much better work product.
If your car breaks down, go to a mechanic. If you're feeling sick, go to a doctor. If you have a legal issue, go to an attorney.
Well, I certainly think that makes a lot of sense.
And, John, you are an attorney. How do we get a hold of you?
Well, we'd be happy to speak with any of our friends listening to us on the radio, or any of your family or relatives who may need a lawyer in a civil trial dispute or business, commercial, personal injury context, or in Social Security. Our office number, 352-547-4292. Our toll-free number is 855-534-2565, and we have offices in both the Villages and Ocala.
Excellent. And for the listeners, if you need any of that information repeated, call us. We'll be glad to tell you the information over the phone, or go to WOCA.com, and under Legally Yours on every Wednesday, you'll see it listed right there under the guest list for AM Ocala Live, 1035. John Fuller, thank you so much.
Thank you, Larry. Always a pleasure, and thanks to our listeners and the callers who always call and ask very interesting, relevant questions. I always appreciate that.
Yeah,
Thank
we
you.
do too. Okay, we'll take a little break and we'll be right back.
Ocala's information station, 1370 WOCA.
Ocala.
The weather is brought to you by myfwc.com. Life jackets save lives. Wear it, Florida.